The U.S. Supreme Court made a terrible mistake 23 years ago. It is a mistake that has significantly harmed more than 1 million Americans required to register and their families. Harm that includes death, both from vigilante violence and suicide. The court's terrible mistake was made in March 2003 in the decision Smith v. Doe. In that terrible decision, the court wrongly decided that registration is not punishment, but merely a regulatory requirement. As a result of this terrible decision, new sex offender laws have been enacted and applied retroactively for more than 20 years. One of those laws is Megan's Law that requires states to post personal information on public websites about persons required to register. That information includes home addresses and photos, even if their offense took place before the internet was created. Smith v. Doe, the court's terrible decision, is based in large part upon a myth. The myth that people required to register reoffend at a rate of up to 80%. The source of that myth was not empirical data. The data did not come from a government or academic study. Instead, the source of that myth was a marketing statement published in Psychology Today magazine in the year 1986. That is outrageous. And to make matters worse, the person who made that marketing statement has retracted what he said. The court's decision is also based upon a dubious statement made during oral argument of the case. The person who made that statement, then private attorney John Roberts, representing the state of Alaska, said that the requirement to register was no more burdensome than applying for membership at Price Club, a discount store. This is the same John Roberts who is now Chief Justice of the U.S. Supreme Court. Perhaps at the time, John Roberts had never applied for membership at Price Club. Perhaps at the time, Attorney John Roberts had no idea that people required to register and their families were already suffering from lack of housing, under or unemployment, and the worst social stigma one could imagine. That is why we are here today, to educate Chief Justice John Roberts and the remaining 8 members of the court he leads. We are also here to demand that the court admit Smith v. Doe is a mistake that must be fixed now. We remind Chief Justice Roberts and the 8 associate justices he leads that the court has made terrible mistakes in the past. For example, the court approved separate but equal education in Plessy v. Ferguson, and the court later approved internment camps for U.S. citizens of Japanese descent. The court corrected the terrible mistakes they made in those cases. It is time now for the court to correct the terrible mistake it made 23 years ago in Smith v. Doe. Until the court overturns Smith v. Doe, more than 1 million families will continue to be significantly harmed. Some of them will experience homelessness, many of them will be unemployed, and others will be killed by vigilantes or by suicide. Chief Justice Roberts, it's time for you to lead the court by overturning Smith v. Doe, and it's time for the court to hear our cry. Smith v. Doe must go. Smith v. Doe must go. Smith v. Doe must go. Thank you, guys. Thank you so much.